6250 Daniel Peterson versus NSP Excel Energy and Broadspire. Excuse me. We have Judge Tom Christensen to my right, to my left, Judge Sean Quinn to my right, and I am Judge Carlson. We are recording and live streaming this, so please speak up, speak clearly. I know you both are good at doing that, but that's appreciated. As a quick review on the rules of timing, you will see that you both have a clock in front of you. You have 15 minutes. If you do want to save some time, that is up to you to keep track of your time. When you look down and see you have some time left, say, I'd like to reserve the rest of my time, and please be seated. Once your time is elapsed, it's done. If we have questions that go beyond that, you will certainly be given time to answer the questions. Mr. Manka, you may proceed.
Thank you, and good morning, Your Honors. May it please the Court and Counsel. The facts in this case are well set out in the primary brief that's previously been submitted. The attempt was made at that time to summarize 500 pages plus of transcript, 5,000 pages of exhibits. And after all of that, there are a couple of facts, at least two of which are undisputed. Number one, after the date of injury, Dan Peterson was never able to return to any job other than some volunteer work and some insubstantial employment. He was injured on May 4th, 1980, and that's an important date, and I'll come to that in a second. The second point, and second fact, which is really clear, is his medical condition after the date of injury continued to deteriorate despite ongoing medical care. As his physical condition worsened, he eventually required daily assistance, first from his family, and then since 1989 from his wife. The Sorkin case, which this court is certainly familiar with, set forth the level of cares for which the employer is responsible after the employee is injured. And that's really what this case is about, is those cares and the Sorkin case. There is, in this case, the employer attempts to obtain a windfall, essentially, by imposing upon his spouse the duty for the care of the injured employee, not at the cost of replacing it, but not at the salary the employee's spouse gave up, not for the time actually caring for him, not for being on call at night, not for the hours that the injured employee may need assistance, not for the 12,000 plus days that she cared for him since the time she got married. And they want to, and not for the time monitoring his medical condition and ensuring his safety, but by going back and cherry picking over 5,000 pages of medical records and then imposing some hypothetical minimal wage that the least qualified and the least reliable person might get, and most importantly, and this is what is, I think, what is essential about this particular appeal, not what the law required, namely the charges that exist in the community at the time. That what the employer seeks in this case is not what the statute and the law required, and they should not be allowed to effectively impose on the spouse or the family, without regard to whether that person wants to do it or is otherwise available to do it, to assume the responsibility of the employer due to the injury when the employer refuses to provide those necessary services. All right. The question is sort of is in every case like this is what is the spouse to do? The employer doesn't provide those services, so the employer sits back and has the spouse do it and assumes the responsibility. In this case, for 33 years, she provided those services.
Mr. Manka, here's the one difficult problem I have with your argument on this. The stipulation for settlement takes place in 2020 or thereabouts, and now you're asking for the replacement services dating back to 1989 when the employee got married, and I understand that part, but you have to recreate, in a sense, all of the, not the evidence, but, all of the memory of your client's wife. And at a certain point, it's just a matter of proof. I mean, yeah, you got the medical records, and the medical records do paint a picture of a rather disabled individual. But, the employer's expert says, it isn't as much as your expert said. It isn't as much as your client's wife said. And the compensation judge went with one way. Aren't we stuck with hang a mule in that regard? I mean, maybe from the time of the stip or the time your client's wife started keeping better track, sure. But before that, isn't it just a matter of hang a mule?
It really isn't a hang a mule case. It's not a hang a mule case because you have to look at what the expert relied upon. And if the foundation of the expert's opinion is flawed, lacks proper foundation, then you never get to a credibility question, is what you're referring to, Judge.
Well, it's more of just not even credibility so much as just, this is more persuasive to me, the compensation judge, than this. I mean, that seems to be what the judge did.
But it's kind of like if you close your eyes and say in the middle of the day, it's night out, that doesn't make it so. You can't ignore the medical records. You can't ignore the caregivers. And if you ignore all of those things, the foundation is so flawed, it cannot rise to the level to support a substantial evidence to support the decision. That's why it's not a Hingemüller case, Judge.
Okay.
At least what's crucial in this case, and I think the court probably picks up on this, is the Joyce decision. Under Joyce, the law in effect on the date of the injury governs it. And that can be good, it can be bad, but that's been the law for a long time. In this case, the essence of this dispute is really the error of law when only one witness actually looked at what the law in existence at the time of the employee's injury and what the liability of the employer should be at that time. And that's under, excuse me, 176.135, when under subdivision 1, it says reasonable value, but then it defines what the liability of the employer is under subdivision 3. And that is very clear. The charges, therefore, as prevail in the same community for similar treatment. And that's, I think, really dispositive. The Minnesota Supreme Court in the 1983 decision, Novotny, explored that and ruled on that. The Berg case, or the Johnson versus Berg case later on, really laid that out. And the court was clear in that case when they said to determine the reasonable value, we are to consider what other providers in the community charge for the services. That's Novotny. That's quoted in Johnson. And they go on. The compensation judge concluded the employee would have to pay this amount to obtain those services. It's really a replacement value. And that's really...
So, Mr. Maka, just to be clear, so the statute that you're referring to, 176.135 sub 3, was repealed in 1992.
Correct.
The part about the replacement services being the reasonable value. So your argument is under Joyce, we should be looking at 176.135 sub 3 because of the 1980 date of injury.
That's correct.
Okay.
Under Joyce, you have to.
Okay.
I don't think...
Regardless of when he was stipulated to be permanently totally disabled.
Doesn't matter because the employer drafted the stipulation. They didn't have any reserves. They didn't say, geez, this is going to be this or that or the other things. They didn't reserve any of those things when they drafted because the stipulation itself was going to be really beneficial to the employer if we were able to get Social Security. And unfortunately, we weren't because they would have been entitled to a substantial offset and an ongoing offset. So it would have had value to them, certainly. Back at the time the employee was injured, there was no caps on temp total. There was no caps on perm total. They were the same. And there was really no question about the fact that the employee had been permanently and totally disabled from the time of the injury. And as a matter of fact, Mr. Kipper testified in this case that, in fact, he had been, and the judge obviously concluded that. When we tried to take the deposition of the attorney for the employer who drafted it, the judge said, no, it'd be irrelevant. It was appropriately so.
Okay, but then Ms. Urban makes a point in her brief that your expert wasn't really looking at community rates anyway. She was looking at more of a national rate. And so, I mean, what is a community rate? What is a national rate?
But she at least looked at that. She didn't look at what the wage of the least qualified, least potential person, if you could have been an undocumented Haitian refugee that might have taken this job, whatever. You can't look at that. You have to look at, and you're right, Ms. Graham did look at what it would cost in the nation, but she also looked specifically at what it would cost to replace that in Florida. And that, I think, was the Genworth stuff that she used. And so you can't ignore that fact. It is, when you look at this from a de novo standpoint, as you do on a narrative law, I think you have to conclude that the court below simply did not take into consideration, and their witness, the employer's witness, did not take into consideration what the law existed at the time of the employee's injury.
And Mr. Maka, I understand that argument in terms of the valuation, but in terms of the number of hours the experts differed on, you would agree that Courtney Mitchell had medical records, deposition testimony, she met with them, she saw them. She certainly had a foundation to express an opinion on the number of hours that he would have required service going back to 1989.
I think we addressed that in our brief, and I think we addressed that both in the reply brief as well. The problem she has, that Mitchell has, is first of all, she starts out with the premise that her underlying premise of the standard of law, of what the law required, is wrong. You get to the second step then, is then you ignore the caregivers, you rely on somebody who clearly is an incompetent witness, and you cherry pick 500 or 5,000 pages of medical records and ignore what the treating doctors say.
So, well, Mr. Peterson may not have been the best witness at the hearing, but there were prior depositions, and there is no argument that he wasn't clear-headed during that prior testimony, right?
No, there is, Your Honor, if you look at the medical records, because he's simply an incompetent witness on a lot of reasons. He's just a horrible historian as far as things, and you look at it analytically, he's just wrong on so many things that it was improper to rely on any of what he said. And to simply ignore totally what the caregiver says and what the treating doctors say. And if you ignore all of that, you do not have the proper foundation to be substantial evidence to support the judge's determination from the hour standpoint, as well as the replacement rate. I'd like to reserve my additional 3 minutes.
I do have one other question, though. What about her own personal observations?
In a period of time, she observed him, which was probably 20 minutes or 30 minutes on one day. That's insufficient, Your Honor, I believe. You know, it's like the adverse medical exams that we're all familiar with when the doctor examines him on one day for a 2-minute or 3-minute exam. Those are simply not that reliable. And it wasn't in this case, because the overwhelming weight of the existing evidence, all of the other evidence points otherwise. Thank you.
Good morning. May it please the court and counsel. On behalf of NSP, I'd like to address 3 main points. The first point is noted in our cross appeal that NSP is asking that the words, quote, due to immobility from his previous spinal injury, those 8 words be removed from finding 33. It appears to me, based on the briefing, that there's no dispute from appellant that that was not to be an issue at hearing with respect to determination of the lower extremity causation. So that was an agreement on transcript volume 1, pages 29 to 30, that bills regarding that hospitalization were only allowed to show dates he was in the hospital, nothing more. There was not supposed to be any causation opinions raised or addressed in that findings in order as to the hospitalization. So we would like those words removed from finding 33 as probably just either Judge Daly just quoted a report or maybe, accidentally put those in there. I mean, he certainly didn't award the bills in his order and he didn't address anything in his memorandum. But just to be clear on the findings, we think that should be corrected. The second point we would have to make is this is a Hengamule case. Substantial evidence existed in the record to support Judge Daly's determination of the weight and credibility of the evidence as to extent and nature of home health care services provided by the family member. This request here today to reconsider the evidence and reweigh the two experts is really not appropriate to do so before a reviewing body. In their briefing materials, they admit that Courtney Mitchell's opinion was thorough and methodical, but that their belief was that the judge, quote, should have liked Ms. Graham's opinion more. Well, 10,000 times, there's times when I have had decisions in work comp where I think the judge should have liked my expert more, but I don't come running up here, with sour grapes. So I think the Minnesota Supreme Court has already said in both the Maddock, M-A-T-T-I-C-K, and Giannotti, G-I-A-N-O-T-T-I cases, that if an expert has enough facts to form a reasonable opinion not based on speculation or conjecture, that's enough. That an expert has foundation essentially is the trial court's discretion, and the appellant must prove abuse of that discretion in order to overturn the findings. Here, it's our contention that the appellant cannot possibly say that Judge Daly abused his discretion in selecting Ms. Mitchell's opinions over that of Ms. Graham's. Ms. Graham in this case actually met with the injured worker in Florida. She flew down there, met with the person. There's nothing in the record to suggest it was only 20 minutes. It appears to me, based on the report, it was quite lengthy. She reviewed thousands, and I mean thousands of pages of records, deposition, transcripts, met with the injured worker and the wife, did a personal assessment, watched the employee sit, stand, walk, all of those things. Their expert, Ms. Graham, did none of that. She only talked to Ms. Peterson over the phone. She never personally saw or examined or assessed the employee in any nature of any kind. Judge Daly also had the observation to be able to, assess both of these witnesses in person and listen to their testimony. This was a 2-day hearing. Ms. Mitchell sat through all 2 days. She listened to Ms. Graham's testimony. So she had already heard Ms. Graham's testimony at the time she testified. There's just simply no way here to say that she didn't have enough information, which is the standard, to have foundation for her opinion. There's nothing that says foundation must be perfect. It must be adequate. And here it was.
Mr. Obama, can we talk about the issue of valuation? You heard
Sure.
Mr. Manka say because
That's
of
next.
because of Joyce, we should be looking at the laws that existed in 1980 regarding valuation. What's your response to that?
Sure. I would say in this case, the replacement services didn't even come into effect until 1989, which is when they got married. Secondly, I would say that under the STIP, there was no adjudication of perm total status until May 17, 2020. Third, I would say that even though the standard says charges that prevail in similar communities, it still doesn't say must use agency rate. That's not in there. So I would dispute that looking at charges that prevail in similar communities mean replacement services or means an agency rate. I don't think that's what the statute says. So even if you use it, I don't think that's what it says. But once that becomes repealed, then I don't think it's valid anymore. Whether the date of injury in 1980 is what it is, but if you repeal a law and it shouldn't be applicable ongoing when all of these services were not even requested until 2021 retroactively.
But under Joyce, wouldn't the 1980 law still apply even though they're not requested, even even after it's been repealed, the 1980 law would still prevail, right?
Well, I don't necessarily believe that's the case with this benefit, because she wasn't even married to the employee in 1980. So, I mean,
Well,
I
I mean,
don't think I don't necessarily think that that benefit was even in existence at the time. But like I said, even if you agree, even if you say that law applies, I'll live with that, because I don't think that the standard is what he says it is. It's not, you must apply agency rate. So even if you find that we have to use subdivision 3, great. You know what? That doesn't really bother me that much, because you still don't get to agency rate.
All right, so let's assume that that's the case.
Okay.
That the law clearly doesn't say agency rate. I mean, that's for sure. But let's assume we decide the 1980 law applies, it should be the community standard rate, whatever that means. Does that mean we have to remand?
No, because that's what Courtney Mitchell essentially already did. If you look at what her opinion says, she went to dollar value of a day. She says she looked at what the hourly rates were in Florida at the time, and then she used that, and then she correlated those each year going forward. So she already looked at what the community rate was prevailing for someone who's not providing medical services. So, let's be real here. The employee is not providing medical services that need a nurse or an agent. She's running to pick up prescriptions. She's cooking meals. She's doing laundry. What's being done here is the sort of expanded definition of care under SORCM. So it's not like she's providing things that need a licensed nurse or agent. Courtney Mitchell says that in her report. You'll see Courtney Mitchell specifically states this person is not doing anything. Miss Peterson is not a nurse. She has no medical training. She's not performing services that a nurse would need to be prepared, or even a PCA. And there's nothing in Courtney Mitchell's report that supports the allegation that she went out and used the rate for an undocumented Haitian. That's not in the record, and there's no evidence in that regard. What she said is she looked at what nursing or non-medical people do to perform these services, and that's the rate she got. So she already used a community rate. It's just not the one they liked. They want the higher one. They want the agency rate. And Courtney Mitchell explained why agency rate is not the community standard. So if you use the 1980 law and you have to look at the community standard, Courtney Mitchell already did that for you. And Judge Daly, to be honest, already did that for all of us. So he already went through Courtney Mitchell's report and Courtney and Miss Graham's report, and he already weighed the rate. And he said that the most persuasive rate regarding what this person, Miss Peterson, should be paid for what she's doing is the rate assigned by Miss Mitchell. And is there an abuse of discretion to show that was wrong? I don't see one. And go ahead.
Quick question quickly on that. As I read the decision of Judge Daly, he used, as you noted, Ms. Peterson doesn't have any nursing background, but he seems to at least indicate in my review that he used a home health worker person and rate and value in Florida during this period of time where the claim is being made. Is that a correct understanding, or am I wrong?
No, I think that's what Courtney Mitchell did. I mean, I think that's what she says in her report. She says, that there's no specific nursing services being needed. These are mostly household things. But when she goes through, I should have brought the report with me so I could have quoted right from the report, but I couldn't bring 10,000 pages with me. But there's a part in Courtney Mitchell's report that talks about, she looked at, like what a nurse's aide would be paid, or what the hourly rate would be for a nurse's aide. And that's where she got her $12.45.
And that community rate that she was using, that was based on Florida, as
Yes.
I read it, and not Minnesota.
Right, because that's where the services are being done. Correct. And I think her problem with the Genmarth standard was that that's national across the US.
Can we talk about the STIP?
Sure.
Okay.
That's, yeah, so that's kind of next.
So,
Go ahead.
and if you don't mind, we'll just have a couple of questions. And we understand that it wasn't you or your firm that did the STIP, okay? But our question for you is, what part of the STIP is ambiguous?
So I don't think that the STIP really is ambiguous.
Well,
I
if it's-
think it says what it says, but what I think is they're trying to do to it is read into it more than what's actually written.
Well, and I would argue that that's what you are trying to do, because it seems we're required to give it its plain meaning. And a stipulation to permanent total disability seems to have that plain meaning, and that you're asking us to read something more into it in that it was limited.
No,
So
I
what-
don't want you to put any additional words in there. So that's my whole point. The stipulation for settlement is devoid of any reference of any nature or any kind of that stipulation of permanent total disability status being relevant to any other benefit. So if you read the STIP, it essentially was a STIP to reclassify temp total to perm total. That's what that STIP did. It did nothing more. And that STIP wasn't entered into until May 17, 2020 was the date of the award. And it wasn't until after the ink on that STIP was dry that then all of a sudden there's a 40-year retroactive claim for perm total based on the Gummonson standard, which is the easier standard in which to get benefits, right? So our feeling is that they shouldn't get the benefit of the Gummonson standard until he's been adjudicated perm total. He was not ever adjudicated perm total between 1980 and May 17, 2020. He just wasn't.
Would that mean then, and I realize this particular employee ended up not being eligible for Social Security, but hypothetically, he was eligible for Social Security. Would that mean, oh, you don't get the offset until the STIP too?
Yeah, I'm not exactly sure. I personally think the STIP's not, really worded that great, actually.
Yeah.
But,
I mean,
but we have to deal with what
Right,
we have to
yeah.
deal with.
And again,
And I
I
don't
know
know
you
what
didn't
would
do
have
it like
happened, and I don't know
Carlson
what
said,
would have
but-
happened under those circumstances.
Yeah.
But to be honest with you, I don't know. But what I do know is the STIP just has no words in it that they're asking you to plug in.
Well, what the STIP says is, this man is permanently totally disabled and has been so since 1980, the date of the injury. That's what it says.
Yeah, that's not exactly what it says, but.
But, I mean, those aren't
you've
the word
seen
for
it,
word, but
yeah.
I mean, it doesn't say that,
Yep.
Boy, we really should have thought he was permanently totally way back when.
Yep.
He is.
But my point is the date of the adjudication of that, or the date that becomes adjudicated, isn't until May 17, 2020. So yes, they retroactively said that, but it wasn't adjudicated until that date.
Well, why didn't you use that? I know you didn't draft it, but why didn't they use that date?
Well,
And then I look in the
don't know.
stipulation, and it says that the employee reserved all other claims. Employer insurer reserved all other defenses to the thing. And as Mr. Manka said, I'm trying to figure out, usually in a contract, somebody gives something, somebody takes something, there's, some kind of consideration. I'm trying to figure out in the stipulation, what did the employee get out of it, the employer got some hypothetical, offset, but the employee doesn't appear to have gotten
Yeah,
anything out of
nobody
it.
ended up getting anything from the STIP, to be honest. The STIP ended up providing nobody any benefit at all. But to me, and I'm just going to finish on this point because it answers your question, sir, but it is a distinction without a merit anyway. So this is all great happenstance-all chatter, but if you read Judge Daly's decision, he used the Gummonson decision anyway. So the whole point of me arguing about when the STIP was adjudicated was because we were trying to get the Ross standard to determine when and at what amount benefits were payable. But if you read Judge Daly's decision, he rejected Ross anyway, and he never applied the standard. So he already gave the employee the easy standard of Gumminson. So what is the harm here? Judge Daly already gave them the lowest standard you can give someone for proving benefits. There's only two standards, Ross or Gumminson. Gumminson is the easy one, and that's the one Judge Daly used. So whether or not at the end of the day the employee was adjudicated perm total in 1980, if you want to create that fiction, Judge Daly already gave them the Gumminson standard. The only reason why this issue was really important at the time of the hearing was because of the penalty claim. And if that doesn't come through in the briefing materials, I apologize for that. But the whole point was, listen, we should not be penalized and deemed to have known that you were going to apply this Gumminson standard back to 1989, which is when they got married. And we think you should be using the Roth standard up until May 17, 2020, because that's when he was adjudicated perm total. Now, Judge Daly didn't buy that argument. I get that. And quite frankly, my client's willing to live with the Gumminson standards, provided you don't mess around with the choice of experts. But as I noted in my materials, if you're going to futzel around with the choice of experts and you're all of a sudden going to overturn Daly and you're going to supplant your judgment and you're going to give them Graham's opinion, then all of a sudden my client's looking at 30 some years of penalties for using a standard that was not adjudicated until May 17, 2020. So I think, it's really only relevant, this whole issue of the STIP and when it's adjudicated and what we're going to do about all of that only becomes relevant on appeal is if you overturn and you supplant judgment and you adopt Graham over Mitchell. Otherwise, my client has already paid the $101,000 that was awarded based on Mitchell's. In fact, my client paid that after the discovery order in September 2022. So we've already lived with what Judge Daly did, and we're fine with it. We're just not fine with you taking away Judge Daly's right to choose Mitchell, and then on top of that saying, oh, and by the way, pursuant to the STIP, you should have also known that you didn't have a Ross defense up until May 17, 2020. That's what we're not okay with, if that answers the question.
Okay. Thank you, Ms. Urbano.
Okay, thank you.
And Mr. Maka, I believe, okay, your time's coming back up here, 2 minutes and 20 seconds.
I thought I had a little more than that, but that's fine.
Well, and if we have questions, we'll keep talking.
I've been
Thank
down
you.
that road before, Judge. I know,
So just to
understand.
follow up, Mr. Manka, my last question to Ms. Urbano was, in looking at that STIP, what benefit
I was
did
just
the
going to
employee
address that,
get?
Judge. And what he would have got, if he got Social Security, he would have got Medicare, and that's huge. That covers, as many of us, if we're getting to a certain age and we get to that ability to get Medicare, it covers so many more things. It would have been a wonderful possibility for him. Unfortunately, that didn't come into fruition. So that's what he would have gotten from the bargain. What they would have gotten was probably maybe even more valuable. What I wanted to address was, and Judge Carlson's point of, geez, it doesn't, and Ms. Urbano's saying, well, it doesn't say you have to use the agency rate. The Supreme Court did, though, in the Novotny case. The Novotny case says, to determine the reasonable value of nursing care, we are to consider what other providers in the community charge. Providers. The whole point that Ms. Mitchell keeps talking about is wages, and that you can't talk about the wage and comport that with what the statute says. It's the charges. What Novotny says. It's what the other providers do in that community. And that's what you've got to look at.
Isn't that what Ms. Urbano just said, though? That Ms. Mitchell used what other non-medical providers charge because your client's wife is not providing medical services?
No, that's not what she says.
Okay.
What Mitchell does is he looks at the wage and talk about speculation. She's talking about a hypothetical theoretical person who might be willing to take the job of getting up during the middle of the night and doing all of those other tasks, but not at the charges that exist in the community and what other providers would charge. She's looking at what the least possible wage you might pay that person, not what Novotny says, and certainly not what Johnson says in the Johnson versus Bill Berg case. And you can't ignore that. And counsel doesn't even attempt to try to distinguish those or suggest somehow that those are not precedential. They are precedential. In this court, unless we're going to overturn Joyce and overturn Sorkan, that's not what you can do. So what we're asking in this case, and counsel raised it, or judge raised it, do you remand this? I don't think so. I think what you can do is you can go back and that the court reverse the compensation judge's refusal to award penalties, first of all, because the nonsense about perm total versus isn't really perm total is silly. Doesn't pass the straight face test. But what you can do is substitute your own findings onto the amount of cares required, and then adopt Ms. Graham's on the value as well as the hours, because it is simply comports with the statute at the time. Any questions?
Questions?
Thank you very much.
Mr. Mika?
This is not a question, but it's a question. Simply, and I only bring it up because you just brought it up on rebuttal. Your client did not get Social Security disability.
He did not.
Do you know the process that he went through to try to get it?
You do an application. I don't do,
Yeah.
I've never really done a lot of Social
Okay,
Security work.
I did a lot, so that's why
Okay.
I'm asking.
I think he did the initial interview or the initial application, which you can actually do over the phone.
Yep.
And I think he was at that time, I think he got some assistance from my office, frankly, to how to, give them all the information, the rest of that. And at which point they came back and said, there's a term of art in the Social Security. You're no longer an insured.
He didn't have enough
Date
quarters
last
of
insured.
coverage or whatever, yeah.
Yeah, date last insured, I think was the thing. And it was too
All right,
long.
So it is an absolute long shot, absolute because of the time here. But with that said, your client, if he's still interested in getting Medicare, he should apply for Social Security and claim that his onset date is before the date last insured, which presumably
Would
was
be 19.
around the time of his date of injury.
You can do that?
Can. Now, you have to prove ongoing disability from that date up to the present, no gap in time, and that means you need 40-some years of medical records, and that's going to be hard, but it's a possibility.
I may refer him to.
It's a risk.
I may refer him to Greg Nelson on that.
There you go. And then that might benefit your client, Ms. Erbon, potentially.
Counsel,
Who
thank you
knows?
both. Your briefs and your presentations today were excellent and very helpful. The matter is now closed, and we will have a decision within 90 days. Thank you.
All rise.